Hearing the appeal, Livingston Properties Equities Inc and others against JSC MCC Eurochem and others.
Yes, Mr. Fenwick.
Good morning, my lords, my ladies. In this matter, the representation is as per the sheet in front of you, save that my learned friend Addo, Mr. Pease, also appear with me. I thought it would be just helpful before I begin my submissions to identify, because it may have some limited relevance, the position of the 18 defendants to this action. There are effectively 4 companies, BVI companies. The first and 6th defendants, Livingston and Rumbai, BVI companies, and the 14th and 15th defendants, Darlow Enterprises, Panama, and Darlow Investments, Scotland, which play no part, default judgments having been entered into against them and liquidators having been appointed. Mr. Rogalski, the 8th defendant, has a pending challenge to jurisdiction awaiting the outcome of this appeal. Mr. Permitkin has been served but has not played any part at all. There is a default judgment application for damages to be assessed pending in front of the court in BVI, which Justice Adderley adjourned over again until the result of this. In case there was some relevant outcome from this appeal which might affect it. The 18th defendant, Dremont, has reached an overall settlement with the claimants and plays no further part in the appeal. In addition, the respondents before the court fall into 2 parties. The other BVI companies, so those served as of right, D2 Nimati, D3 Nautilus, D4 Global Med, D57 and D17 Giant Hill, have disinstructed their solicitors, and although parties to the appeal, don't appear and make no representations. So the representations come from the 10th to 13th respondents, Mr. Baysand from Switzerland, copyist of BVI, alleged bribe payer, iTrade, a Swiss alleged bribe payer, and Mr. Scallambrin from Switzerland. And secondly, Dearborn, which is a Cyprus company said to be owned by Mr. Rogalski. Against that background, can I come to deal with the matters in this appeal? But before I deal with the specific issues, the defendants who are involved in these appeals are all non-Russians. Mr. Rogalski and Mr. Permitkin are not parties to the appeal. They may or may not, in the event, participate at all in the trial. The claims against these defendants are based on an international bribery scheme causing massive loss, principally if not exclusively to a Swiss company, ECTG, the second claimant. And when we come to look at questions of law and forum and applicable law, I start with the proposition that bribery is a wrong recognized in all civilized legal systems, giving rise to recovery remedies, even in Russia, as the experts agree, The duties which we plead in our statement of claim are not duties said to be owed by Mr. Rogalski or Mr. Permitkin under the terms of their employment contract. They're duties which arise out of the fact of their employment and out of the duties which they owe to ECTG, the second claimant, the Swiss company. True it is that their employment contracts as such are likely to be governed by Russian law, and there's no contest between the parties on that. But it is a big jump, we will be saying, from that fact to conclude that the governing law of these claims is Russian law, let alone that Russia is the appropriate forum. It's further down my list of grounds of appeal, but I want to start by just identifying the question of discretion. This committee will be very well aware of the cases which make clear that an exercise of discretion by a judge in this kind of forum challenge is not to be disturbed. It has all the protection of a discretionary decision. It's an evaluative assessment by the trial judge and should only be disturbed if the trial judge can plainly be shown to have exceeded the wide ambit of his discretion or to have got it wrong by omitting material factors or giving too much, omitting material factors or giving too much weight to immaterial factors. When we come to look at the approach of the Court of Appeal, which in our submission had no proper grounds to overturn the exercise of discretion by a judge who had carefully examined circumstances and had come to a reasoned and apparently sustainable decision. But when the Court of Appeal embarked on its analysis through Justice Webster, it's important to note that it carried out its analysis on the basis of the stay application. That is to say, it was looking at the test for a stay brought by defendants served as of right because they were incorporated in the BVI and served in the BVI. And they were seeking to stay the proceedings for which, and again, using loose words at this stage, they would have to demonstrate that there was some other available forum which was by far the appropriate forum for the fair disposal of the case. The Court of Appeal, having reached the conclusion, we say wrongly, that Russia was an available forum and was the most appropriate forum for the trial of this matter, used that as a springboard to deal very briefly with the other side of the coin, that is to say, the application by the respondents with speaking parts today to set aside service. And I accept that if the Court of Appeal were right to conclude on the first test that there was an appropriate forum which was by far the most suitable forum, then it would follow that we would be unlikely to show that Russia was not the most appropriate forum on the second stage. It's, I think, convenient. One can approach the questions found by the Court of Appeal either from whether Russia was an available forum, as both Justice Wallbank and the Court of Appeal did, or from first of all asking the question which in effect dominated the decision of the Court of Appeal, which is what is the governing law of this litigation, if any. Now, it's perhaps understandable that the Court of Appeal and the judge started with Russia, because it was the case for all of these respondents, defendants, that they asserted that Russia was the most appropriate forum. They identified it as the forum where they said these matters should be tried. But they did so with respect, without first establishing that Russia had a suitable connection. So I'm going to go, if I may, first of all, to deal with the question of governing law, and there are two questions which come at the outset of that. The first question is whether, in a case where foreign law is engaged in the sense that the acts or tortious acts or omissions and or the loss are likely to have been or were suffered outside the forum, in this case BVI, whether, as the Court of Appeal found, it is incumbent upon a claimant to plead and prove that foreign law in all circumstances. And secondly, whether the learned judge, in circumstances where he was satisfied that there was a viable cause of action in tort, nevertheless should, as the Court of Appeal appear to think, to have found, have gone on to determine what was the governing law of the contract, of the cause of action, before deciding on the question of appropriate forum. Now, perhaps we can look and see, first of all, what the Court of Appeal in their judgment said about this matter. It's in Volume A, and I will, if I may, use the electronic versions, which I think, by dint of a great deal of late hours, should reflect correctly what is in your electronic bundle. I see that some members of the committee are using paper bundles, and I'll give the paper bundles as well if that's convenient.
I think I'm the only dinosaur.
What is the page number in the...
I'm going to go in the Volume A, I'm going to electronic page 57, printed page 53, which should take us to paragraph 46.
I'm sorry, whereabouts in Volume A?
In A, it's tab 5,
Thank you.
page 53 of the printed, 57 of the electronic. And learned Justice quite rightly says that 46, the governing law of the claim, is an important consideration in determining the most appropriate forum. Then quotes from Lord Mance in Nutritech, governing law in general terms a positive factor in favour of trial in the place of the governing law because it's generally preferable, other things being equal, that a case should be tried in a country whose law applies. However, that factor is of particular force if issues of law are likely to be important and if there is evidence of relevant differences in the legal principles or rules applicable to such issues in the two countries in contention as the appropriate forum. Again, that this analysis shows the governing law of the claims is important because there are important differences between Russia and BVI in the legal principles applicable to the claims and the available remedies. And the committee will see that he's already jumped to a choice between Russia and BVI. He then correctly goes back to the starting point in a tort claim, which is the place of commission of the acts leading to the filing of the action. And as he found elsewhere in the judgment, in common with the learned judge thus agreeing with him, this is a case involving bribery of international proportions. There is no satisfactory evidence of the place of commission of the wrongful acts. And that's important because we put in our evidence, and the reference to it is in the 6th affidavit of Mr. Popov, which I'll give the reference, volume E, tab 61, page 1285 in the electronic and 1247 in the paper copy, going on to the next page, where he says that the events underlying the claim occurred predominantly outside Russia and explains some details in relation to that, including 350 business trips taken by Mr. Rogalski outside Russia. By contrast, the defendants, none of whom are in Russia or Russian apart from Rogalski and Permitkin, not appellants, respondents, not parties to this set-aside application, have not at any stage produced evidence as to where any interaction between them and Mr. Rogalski, Mr. Permitkin, or between each other, this being pleaded as not only a bribery scheme but a conspiracy, took place. And a typical way in which that is pleaded in the multiple witness statements put in on their behalf, and I take an example in the case of the third and fourth defendants, which is in volume E, tab 54, 1208 in the electronic, 1175 in the paper bundle, where at page 1211, 1178, paragraph 9, it simply said, and this is repeated in many of them, it appears that most of the acts of Messrs. Rogalski and Permitkin complained of will have taken place in Russia. The relevant witnesses will similarly be Russian. To the extent they didn't take place in Russia, they didn't take place in the BVI. So it's not evidence they didn't, but simply a suggestion. So,
Sorry, could you please give me the reference to that again?
Yes.
Yes, of course. Make sure I give you the correct one, having. Yes, it is. E, tab 54, and the relevant page, paragraphs 9 and 10, 1211 electronic, 1178.
1211.
11.
Thank you.
It's not surprising that in such a scheme, where the acts by which bribes were agreed, instructions were given for price reductions, and monies were agreed to be transferred and were received, we aren't able to identify the place where each of the acts occurred. But it is important to bear in mind that we are, of course, not just talking about the acts of Rogalski and Permitkin. The torts which are relevant in this appeal are the tortious acts of these defendants, which do not depend on what Mr. Rogalski and Mr. Permitkin did, and could have easily have taken place, and we say did take place, elsewhere in the world. And I've already shown you the locations. They are situated. Graham, which has dropped out, was in Singapore. We have Turkey, Switzerland, Cyprus, and a large number of BVI companies. We also have, as you will see from the particulars of claim, bribe payers who have settled. Yara in Norway, ETP1, ETP2, ETP3, identities disclosed, European entities. So,
It might be helpful for us to see the particulars of claim. Do you know where we might find those?
yes, indeed. I have it. It is in volume D, tab 32, page 964 in the electronic, and page 944 in the paper bundle.
Thank you.
And I'll just show a couple of key elements here. First of all, paragraph 2, and this was picked up by both the judge and the Court of Appeal, that Eurochem Trading, the Swiss company, purchases fertilizer products from Eurochem and sells them around the world. So the losses on sales at a discounted price would be suffered by Eurochem Trading. And no doubt it would be said that any claim for those losses by Eurochem will reflect loss. If we look at paragraph 4, sets out the details of the BVI companies. 5, Rogalski, employee of Eurochem, and a manager and agent of Eurochem Trading, that's a Swiss company. Member of the Managing Board. And 3, curator of Eurochem Trading, which, given the duties and responsibilities, results in being deemed an agent and de facto director of Eurochem Trading. Then Permitkin over the next page, employment contract with other positions with both, deputy head of marketing of Eurochem, agent of Eurochem Trading, and then the pleading of essential case against the BVI companies, received substantial sums of money which at all material times they knew represented secret commissions being paid to or for the benefit of Rogalski or Permitkin, paid by or on behalf of entities trading with the claimants, who all knew they were unlawful secret commissions. And there's a long list annexed to the particular claim. Paragraph 9, the claim for dishonest assistance by receiving, holding, and distributing secret commissions. They were both recipients and transferors of bribes. Conspiracy. Duties of Mr. Rogalski and Mr. Permitkin, pleaded at page 969, electronic 949.
Before you pass that over, can I just ask you a question about paragraph 11
Of course, my lady.
on 948? Because you just, before we went to these pleadings, said that the torts which are relevant here are those of these respondents which do not depend on what the 8th and 9th defendants did. I think that's the proposition you advanced.
Yes.
But if you look at paragraph 11, it said that those two defendants caused the BVI companies to act as they did.
Yes.
So, in that sense, one of the, I think defendant 11 is a BVI company, is that right?
No. It is a BVI company, but it's a bribe payer.
Yes, but in the previous paragraph it talks about the conspirators and or payers.
Yes.
So they're
Yes.
included in this. So does your proposition hold good?
Yes, it does in two respects. So far as copist is concerned,
As far as what is concerned?
Copist, the 11th
Thank you.
defendant, copist was, we say, a creature of the parties represented by Millennium's friend Mr. Rees. They were a bribe payer. The paying of bribes was at the direction of one of those other parties, Mr. Scalabrin, Mr. Baysan, or iTrade. So they do not fall within that paragraph, and I accept the BVI companies is perhaps not sufficiently clear for that. In fact, they're defined, paragraph 4, as the 1st to 7th
Right.
and 17th defendants.
That
So
may be the answer. Thank you.
but the second part of your question, where, and I think the starting point, where we say that Mr. Rogalski and Mr. Permitkin caused the companies to act as they did, then that, of course, is a control argument. But it's common ground, or at least the learned judge found, although the Court of Appeal treated it slightly differently, that BVI companies can only act through their registered directors. So even if the registered directors were told what to do by Mr. Rogalski, and that's not unusual in the case of such companies, the actual relevant acts of receiving money and transmitting them must have been done by the registered directors. There is a complaint, I think it's again in the judgment of Justice Webster, that we do not plead or provide evidence as to what acts, if any, were done by the registered directors, or even who they are. And of course, when I come to deal with the submission that claims of this sort using BVI companies are claims for which there is a strong argument that BVI should take jurisdiction. The fact that BVI permits companies to be incorporated with directors whose identity cannot be ascertained. We can't go to Companies House in Road Town, Tortola, and ask who the directors are of these companies. There is a complicated procedure, applications to the court in certain circumstances with evidence to get it. So they're able to hide behind them, but nevertheless, the acts of the company are the acts of the directors. And it is wrong to say that what Mr. Rogalski may have done in Russia means that the test of whether the BVI company receiving monies and paying it out is to be determined under Russian law.
Sorry to take you off your course, but thank you for pointing me to paragraph 4.
Sorry to rise and interrupt, but it wasn't common ground, but it was the registered directors who acted on the issues that was raised as whether or not Rogalski and Temkin de facto directors of these companies. Thank you.
My learned friend says it's an issue, but of course he's never pleaded to this case, nor is he ever put in a witness statement in which he asserts. There's no witness statement from any of these BVI companies saying we acted through our de facto directors, Mr. Rogalski and Mr. Temkin. Indeed, there were denials until a very late stage that Mr. Rogalski and Mr. Temkin had anything to do with any of these companies. It was only when documents were discovered that our suspicions became clear. The judge goes on to say, the judge didn't make a specific finding of governing law. Page 45, summarizing the reason for finding BVI as the appropriate forum. The fact that Russian law is the natural lex causa of the employment relationships. The context of what he's saying, this is a finding that Russian law is the governing law of the employment relationship between the Russian defendant and the claimants. But it does not go so far as to say that Russian law is the governing law of the claims. We say rightly so. And he then came to the first substantive point that I want to deal with, which is saying correctly that the judge dealt with governing law, dealing with our failure to plead law by saying that the lex fori will apply BVI law, following the rule in Dicey and Morris, conflict of laws. In the absence of satisfactory evidence of foreign law, the court will apply English law to such a case. In my opinion, that is not the proper approach in this case. In the first place, this is not a case where there is no satisfactory evidence of foreign law. There's ample evidence of Russian law by the two experts. Therefore, the default provision doesn't apply. Challenge that. Secondly, the claimants cannot seek to benefit from their own default in not pleading and proving the governing law of the claims, then relying on that failure to take advantage of the more generous remedies available in the BVI. This is patently self-serving, bears some resemblance to forum shopping. The judge should have carried out the proper fact-finding exercise to determine what is the proper law of the claims in this action. Now, we say the learned judge got an important point wrong in the Court of Appeal in this. And I want to start with this question of principle, and I'll look at briefly at Dicey and at least one authority in support of it. We have had, I think, a number of attempts at, can you get me? Right. I'm told bundles are the same. Can we pick up bundle I, supplemental bundle, tab 4, and I'm told that the number 2953 is common to both the written and electronic bundles. By this stage, those responsible for producing them having found a way of reconciling the differences.
Sorry. Can you give me the MS number again, the electronic number, please?
It's volume I 2953. Should be chapter 9 of Dicey with Rule 25.
I think electronically it might be numbered 1 to 24. No. What paragraph are you looking for?
I'm looking first of all at the actual rule itself.
The rule itself, yes, which is on page 5 of 24 in the electronic version, I think.
I'm so sorry that
It's in a separate file as far as we're concerned.
I was sent it in a separate file as well, but then I was sent it in this.
It is also 2953, but
We're looking for Dicey.
have you got it?
In I, we seem to have Adrian Briggs, but I'm not sure we have Dicey.
Tab 3 is Civil Jurisdiction Judgment by
We've
Adrian
only got
Briggs.
2 tabs.
You have a slim volume. There is a new volume I, which was...
Well, if I can assist, I think it's the Respondents bundle R1 and not bundle I, which may be the confusion.
Yeah, Dicey.
Yes, we now have Dicey.
It's in the other bundle as well. We're just trying to... And I'm not going to keep apologising, but it is a matter of extreme inconvenience to the committee. Imagine. Dicey Rule 25. In any case to which foreign law applies, that law must be pleaded and proved as a fact to the satisfaction of the judge by expert evidence.
Sorry, I was so excited by getting the document. I haven't got the page number. 25. Burden of proving foreign law.
It should be the first page of chapter 9.
I see, okay. Thank you. Rule 25.
In the absence of satisfactory evidence of foreign law, the court will apply English law to such a case. In my submission, although the learned Justice Webster doesn't say so in terms, the proposition is that if you're dealing with an act which took place abroad or where loss was suffered abroad, you must plead foreign law. That is a requirement. It's our submission that that is not part of the law of England or the law of BVI. And I'll look at the authorities in a moment. We can look at the commentary. But the position, if I can encapsulate it before looking at those materials, is that if a party wishes to rely on a provision of foreign law as being different from the law of the forum, then that party must plead it and prove it as a fact, foreign law being recognized as matters of fact rather than expertise.
What strikes me at the moment is that Rule 25 is a rule that applies, as it tells us, in any case to which foreign law applies. We've yet to decide whether foreign law applies.
Yes, I agree. I'm doing it this way because that's the way Justice Webster took it.
Yes.
But there are two questions which one has to ask. First of all, does any foreign law apply? And secondly, if it does, do you have to plead it? If we just assume in this case that it could be shown that all or a majority of the tortious acts took place in Cyprus, then in general, you would look at Cyprus as a lex loci delicti for the governing law, and in order to sue in the BVI, the wrong would have to be actionable both in a BVI and in Cyprus. That's to get your cause of action over the ground. If you want any other reliance on foreign law, you either plead it and prove it, or English law will apply English law to the case. The court will apply English law, and the BVI court will apply a BVI law. There are exceptions, I would suggest, as a matter of principle, to the circumstances in which a plaintiff can simply assert a cause of action, not plead any foreign law, whilst accepting that the cause of action arose because the wrong was committed outside the forum. Those two situations, in my submission, can be identified as, firstly, where there is some characteristic of the law you're pleading, which would appear to be different from English common law and English statute. One thinks often of tax cases, whether some particular act in relation to taxation is unlawful in the United States or South Carolina or Egypt, whether the claiming of interest in Saudi Arabia is unlawful. If you're relying on something which is unusual in that sense, then it is likely that it will be necessary to plead and prove it, because otherwise the English courts will, applying English law, not recognize it. The second type of case is where the claimant seeks to plead a tort or set of circumstances or remedies which arise out of some specific kind of English statute, not just any statute which codifies sale of goods or something of that sort, but where there is a specific statute. And I have in mind particularly the Control of Pollution Act, where there are specific wrongs actionable because of the Control of Pollution Act in this country, which may well not be actionable at all in another country. So if you're relying on something of that sort, it may be that the court will expect you to plead the foreign law if foreign law applies because of lex loci delicti, because if you don't plead that it's a wrong under that law and prove it, then you don't succeed in establishing the tort in this country. But in the general case, you do not have to. First of all, because in many cases, it's simply unnecessary to do so. And there are many cases of pleas of fraud, in this case, bribery. It's, in my submission, tolerably clear, as I said at the outset, that most civilized systems will accept that bribing an employee or agent of a business counterpart in exchange for favours is a tortious act, and you don't need to plead it if the other side, the defendant, wishes to say, oh no, it's justifiable in this country, which is where we say the wrong took place, because of such and such a factor, then they plead it.
This is a very familiar situation to me in the commercial court in Scotland. There are a great many contractual disputes where the contract is governed by English law, but it's unusual for anybody to take the point, and the court proceeds on the assumption that English law is the same as Scots law. Yeah. Occasionally, the point will be taken if there is a material difference between the two systems. But in reality, although the court is dealing with a contract governed by a foreign system of law, there's no need for the foreign law to be pleaded or proved, and the court will simply default to the assumption that the foreign law is the same as its own.
Exactly so. And can I just show you what the Justice Webster did with this, and then take you to the authorities. And he says, in the absence of a clear, this is back at 59 electronic in bundle A, 55 pagination. Having said we were patently self-serving and bearing resemblance to forum shopping, the judge should have carried out the proper fact-finding exercise to determine what is the proper law of the claims in the action. In the absence of a clear finding, falls upon this court to determine it. Claims are a combination of claims in tort for bribery, unlawful means conspiracy, relief to damages. Governing law of a tort in the BVI is determined by reference to the common law of rule of double actionability, laid down in Phillips and Eyre, clarified and confirmed in Boyce and Chaplin. The rule provides an act done in a foreign country is actionable in the BVI only if actionable in the BVI and actionable according to the law of the foreign country. That. Importantly for the purpose of appeal, the rule has an exception in Boyce and Chaplin, which is the flexible exception, as is known. Particular issue between the parties may be governed by the law of the country which, with respect to that issue, has a most significant relationship. General rules difficult to apply in this case because of the concurrent findings by Wallbank and this court that on the available evidence, the place of occurrence of torts cannot be determined. And that, again, is another common reason why, in an international bribery case, one would not plead the law, because we say it happened in Cyprus and they say, no, it didn't. We say it happened in Switzerland and they say, no, it didn't. And where the acts were those of the defendants, who may not condescend to provide any information, it is a fruitless and frustrating task.
Can you help me on a really basic point? It seems to me that there might be two issues here. One is, what is the governing law? And two is, do you have to plead it?
Yes.
Now, I can see that, as I think my Lord pointed out, Rule 25 is about proving foreign law. What's the rule that deals with what is the governing law?
The governing law is, if a claim is actionable both in the foreign jurisdiction, where the lex loci delicti, and in the forum jurisdiction, then the court applies the domestic forum law, except insofar as it's congruent.
Sorry, I wasn't being clear. When I said rule, I meant Dicey and Morris's rule. Have we got it, is the short question.
I'm just going to go. I don't think we have, but we'll make sure we get it.
Thank you.
So if I just continue with this. So having found it's difficult he said, I find it an appropriate case to apply the exception to the double actionability rule and determining the governing law of the tort claims as the law of the country with which they have their most significant relationship in terms of occurrence and parties. This court applied the exception to the rule in I-Management Services and said it is settled at the country with which the obligation has its closest and most real connection. And again, and I will address that in a moment, the learned justice of appeal, having expressly found that the court could not identify the lex loci delicti, then embarked upon a choice between, not as is conventional with the flexible exception, between the forum and the lex loci delicti, but between the forum and some other jurisdiction, for which we say there is no decided case which supports it. There is some wording which, if misunderstood in Boyce and Chaplin, might make one think it was possible. So those are the two issues. Can I go back to Dicey?
Yes, it's all rather confusing. I mean, under the law of the BVI, how does one determine the governing law of a tort? Is it the lex loci delicti, or is it some more holistic, multifactorial assessment?
Well, I'm sorry, I didn't hear the predicate. If it's a case in the...
I was wondering, in the BVI, is the test for determining the governing law of a tort the lex loci delicti, or is it some other test, such as a broader multifactorial assessment of the system with which the tort has the closest connection?
It's the dual actionability test, and therefore it has to be actionable both in BVI, and the word is actionable rather than, I think the original wording was but something different. It's been clarified as actionable as a wrong, both in the foreign jurisdiction and in BVI, and BVI will then apply the BVI law, except insofar as it's not congruent with the foreign law, unless it applies the flexible exception, where it decides that a particular feature of the case has a greater connection with one or other of those two jurisdictions. And we'll see that in the authorities. So can I go, please, first back to Dicey at Chapter 9. We've given the references here in Dicey. I'm just getting back to... can you just find the references? If we go to 9.002 on that first page, representation of foreign law is representation of fact for the purpose of the law of misrepresentation. Findings of finding of fact. It's also said to follow that if the parties elect not to prove the content of foreign law, the case will be decided by the application of English domestic law, though the case was a wholly domestic one. This is generally true. Increasing signs this cannot invariably follow. In cases where it would be wholly artificial to apply rules of English law to an issue governed by foreign law, the court may simply regard a party as pleaded who has failed to prove foreign law with sufficient specificity as will allow an English court simply to apply it, having failed to establish his case without regard to the corresponding principle of English law. So it's got to be a case where it's artificial to apply English law because of some characteristic of either the claim or of the English law. And makes the point foreign law must be proved. And if we go on to 2967, which is page 332 of the book, at 9.025, the burden of proving foreign law lies on the party who bases claim or defence on it. If the party adduces no evidence or insufficient evidence of foreign law, the court applies English law. Expressed in the form, foreign law is presumed to be the same as English law till the contrary is proved. This mode of expression has given rise to uneasiness in certain cases. The court refused to apply the presumption whether foreign law is not based on the common law. Others have been doubted whether the court was entitled to presume the foreign law was the same as the statute law of the forum. And then, if we go to 9-027, the recent practice of the English court also suggests the default application of English law, where foreign law is not proved, is not unqualified, more likely to be challenged whether the rule of English law is statutory rather than being the common law. In principle, an English statute may not be applied to a matter governed by a foreign law in circumstances where the foreign law has not been proved. The English statutory rule appears to state a rule of purely domestic law, where the wording of the statute would need to be adapted or changed in order to be made applicable to facts which do not otherwise fall within it. It goes on in those terms. And if we go on to 9-029, conclusion is there are cases in which the default application of a rule of English law is simply too problematical to be appropriate. But that apart from the fact that the court should not invent a rule of English law to be applied in default of a foreign line, no sharp line exists to define the limits of the principle. In default of sufficient proof, foreign law will be taken to be the same as English law. Now, in our written submissions at paragraph 48, we refer to the recent case which had not been decided when they handed down their decision, but had been decided, was given to them when they gave permission to appeal to this court, of Iranian offshore shipping. That is to be found in H1, tab 24. And it's 2244 in the paper bundle and 2282 in the electronic bundle. This was a case in which at the pre-trial review, the fifth and sixth defendants argued that since the claimant's claim was governed by Iranian law, because that was the lex loci delicti, and it was inappropriate to apply English law, it had been for the claimant to plead and prove the principles of Iranian law governing its claims, and having failed to do so, the claim failed. That was the proposal. The judge held it was not necessary for a claimant to plead the existence of an intention to rely at trial upon the rule of English law, that in the absence of unsatisfactory evidence of foreign law, the court would apply English law to a case to which foreign law applied. That it followed that a plea as to applicable law, or a plea as to the content of some possibly applicable foreign law, was not a material averment a claimant was required to make if the matters as pleaded that it said created liability did not involve or imply the advancing by it of any case as to the content of some foreign law, where a claimant neither needed nor chose to plead foreign law in order to plead what would be a complete and viable cause of action if the claim was to be determined under English law, contention it was inappropriate to determine the claim by reference to English law, so it would fail come to what may, was a reasoned denial of liability, and if a defendant wished to contend it, he should plead it. In other words, unless you want to rely on some feature of the foreign law of supporting your case, you do not need to plead or prove the foreign law. And Mr. Justice Andrew Baker, at beginning of his judgment, paragraph 3, that's 2284 in the electronic, goes straight to Dicey, states correctly the burden of proving foreign law lies on the party who bases a claim or defence upon it. Better to abandon the terminology presumption, simply say where foreign law is not proved, the court applies English law. Little care, therefore, must be taken when reading Dicey, Rule 25.1, lest it be thought to suggest that whenever a claim is governed by foreign law, it's necessary for the claimant to plead and prove the material content of that law, or indeed as a logically prior matter, to plead a case as to a governing law at all. And of course that just picks up those words which we looked at in any case to which foreign law applies. And Mr. Justice Andrew Baker was making clear that you don't read that as saying you always have to plead it. Now, having gone through some of the facts and saying at page internal 86, 2286, letter C, claims pleaded by the claimant without any reference to Iranian law or any plea as to applicable law. He goes on to give his judgment, paragraph 11 on the next page, 2287 electronic. Not necessary for claimant to plead the existence of or intention to rely at trial upon Rule 25.2. It goes without saying that it will apply. Otherwise, it would not be the default rule that it is, unless reason not to apply it is demonstrated. It follows that even a plea as to applicable law, let alone a plea as to the content of some possibly applicable foreign law, is not a material averment a claimant is required to make if the matters as pleaded that it says create liability do not involve or imply the advancing by it of any case as to the content of some foreign law. Claimant matter of necessity pleads in the matter of foreign law, but for which he would fail to disclose a cause of action. Then we get US tax liabilities, or a claimant might choose whether or not it would have a claim by reference to English law, based upon a system of foreign law said to be applicable. Either type of case, different considerations would apply. Where, however, as in this case, a claimant neither needs nor chooses to plead foreign law, in order to plead what would be a complete and viable cause of action, the claimant be determined under English law, as by default it will be. Contention is inappropriate to determine the claim by reference to English law. Should fail come what may as a reasoned denial of liability. Since determination of the claim is a default, under English law is a default rule, even where in principle the law governing a claim is or might be a foreign law, any contention it's inappropriate to apply that rule must necessarily be founded upon matters particular to the claim in question. Principle, therefore, is for a defendant, if he wishes to raise any contention at trial, to plead as a reasoned denial of liability, setting out the matters particular to the claim, said to render it inappropriate to judge by reference to English law. Doesn't do so, no such contention will be open to its trial, subject to 4 below. Particular matters said to render the default application of English law inappropriate might well include, perhaps often will include, relevant propositions of foreign law but not proceedings. With an absolute rule precluding the possibility of relying at trial on a contention that ought to have been pleaded, whether in support of or in defence of a claim, could be a late amendment, grant of indulgence at trial.
Sorry, where were you going? I seem to be reading an awful lot of this.
Yes, I'm just going to take to 12. The analysis supported by the judgments of Lady Justice Ardinson was in OPO and Brownlee. Each passage was obiter, as Lady Justice Arden held in each case, the claimant had a sufficiently arguable case for the purpose of the decision then being taken that English law was the applicable law anyway. That decision being respectively to grant an interim injunction. With respect, I find her analysis compelling. We put both of those into the bundle, and they both support the proposition which Justice Andrew Baker was following. So what I take from that as to the first point of general importance is that it was wrong for the Court of Appeal of British Virgin Islands to conclude that foreign law must be pleaded. The approach taken by us was conventional and particularly appropriate in circumstances where it was out with our knowledge where the wrongs were committed, other than, as we've said, that they were outside Russia, as far as we believe. It would then be a matter for the defendants to assert, either in evidence for the purposes of this application set aside, or in their defences in a trial, that in fact the law of whether it's Russia or Cyprus or Panama applied, because that's where certain things happen. Now, what follows from that is we go to the next point made by the learned judge in relation to dual actionability and the flexible exception.
Just as, you're challenging paragraph 49, are you, of the judgment, is that the point?
Yes.
You say he was wrong to complain of the judge's failure to find...
The judge was entirely right to conclude that it wasn't possible, and the Court of Appeal had agreed with him that you can't identify the lex loci delicti.
There's a certain amount of confusion here. There's a question of a governing law, which I would understand to be the lex loci delicti. There's the question whether the court has jurisdiction, which depends on a double actionability rule.
Yes.
And there's the question of whether you need to plead and prove foreign law, yes, as far as relevant. But nobody doubts that the governing law is in principle a relevant factor in deciding where the case should best be tried.
Yes.
And the judge and the Court of Appeal both seem to have be in agreement that it's not possible to determine what the governing law is at the stage, at this preliminary stage.
Yes.
Yeah. So in that situation, what are they to do? I mean, one possibility is they take the best view they can on a preliminary basis, looking at the information before the court. The alternative that the Court of Appeal seem to be looking at is really just putting it to one side and looking at other factors. What do you say the right approach is?
Well, I entirely accept that when you're looking at whether there is an alternative appropriate forum which is available and more suitable, if you can't identify a governing law other than the law of BVI, you look at the other relevant factors. But in this case, this is not what the Court of Appeal did.
No.
What they did was to say, well, it's all about Russia, and I can jump ahead perhaps in the Court of Appeal's judgment before I look at the next two authorities. I'm keeping a close eye on the clock.
Yeah.
To Court of Appeal judgment A, tab 5, electronic 62, paper 58. Perhaps I start at the previous page, 6157.
Paragraph?
56. The source of the disputes between the claimants and defendants lies in the employment relationship between the Russian defendants and the claimant. Correct in one sense, because they were employed. Incorrect in the sense that this is bribery, irrespective of anything to do with their contracts of employment and what they contained. They were agents and employees, and they were bribed. And the breaches are set out in 57. 59 is important. No pleaded claim for damages for breach of the employment contracts, only that the employment relationship, an agency relationship I should add, created fiduciary duties of which the defendants were aware, and they participated in the breach of those duties. And then he says, those contracts are a part of the background. That I accept. They're exhibited, and they're governed by Russian law. And then at 60, on the basis of the facts as outlined in the preceding paragraph, the framing of the claims in the amended statement of claim, and the terms of the employment contracts, I'm satisfied the disputes between the claimants and the Russian defendants, whether or not they're governed by the employment contracts, arose out of the employment relationship and are governed by the laws of the Russian Federation. Just pausing there. Disputes arising out of their contract would. Disputes as to their role as agents for ECTG, as pleaded, which I've shown you, would not.
But why not? I mean, they're relying there on specific clauses 8.1, which say that any relations during the effective term of the contract, but not governed by thereby, shall also be governed by Russian law, aren't there? So, as I said there, it's very wide. It's not confining itself to disputes arising out of the contract as such.
And it may be that if Mr. Rogalski ever came to a trial anywhere, he would say, well, it all arises out of that, and nothing to do with my agency for the Swiss company. But that's not to say that the next sentence, I would therefore hold that Russian law is the governing law of the claims in the action, is a possible sequitur. Because the fact that Rogalski and Permitkin's liability may, wholly or in part, as far as they're concerned, be governed by their employment contract, which has things like 1 year limitation, 6 weeks salary, and certain things, does not mean that the law of whether or not Mr. Scalambrin, Mr. Baysan, iTrade, copyist, made unlawful commissions to the agent of a trading counterparty, or whether the BVI companies received monies which they knew were the products of bribes, is governed by Russian law at all. It's completely independent of Russian law.
Well, I mean, the first sentence you don't object to, disputes between the claimants and the Russian defendants are governed by Russian law, yes?
Insofar as it
What do you
relates to their...
object to? I thought is the jump from that to saying it covers all the claims in the action.
Yeah.
It doesn't cover all the claims against Rogalski and Permitkin, and it certainly doesn't govern any or all of the claims against the other defendants. And you can't make that jump. So that's the jump that they've made in getting to the applicable law and using that as a springboard for saying Russia is the most appropriate forum and going on to ask if it is an available forum, which they've already looked at in the analysis. But I want to come back to how they get there, because they get there by paragraph 53 by applying the exception to the double actionability rule, determining the governor law of the tort claim, the law of the country with which they have their most significant relationship in terms of occurrence. And there are two authorities I need to look at briefly. The first is at H1 tab 22, which is the I management case. that they refer to. And we just pick it up at the head note, 2224 electronic 2187 on paper. Cukurova Holdings, incorporated in Turkey, brought a claim in tort in BVI for conspiracy, abuse of civil process. In an alleged forged arbitration agreement leading to an award in Russia, came subject to proceedings in Russia, and there were various claims. Then Cukurova filed an action in BVI seeking damages, injunction and declarations. Defendant companies applied for a stay. 3, the appellant has challenged the learned judge's finding Russia is not available forum for the resolution of the dispute. 4, Cukurova's contended in its cross-appeal the learned judge failed to take into account that the extent, if any, the substantive law of Russia was relevant in the action. There was no evidence before the court that any complex issues of Russian law were likely to arise. If we go on to 2241 electronic 2204 paragraph 35. It's well established the role of the appellate court for non-convenience matters reciting restricted to ensuring correct.
Which is your electronic bundle number?
2241, my lord.
Electronic.
Paragraph 35.
Which bundle of authorities?
This is bundle H1.
Tab
22. So this is where they begin with looking at whether Russia has jurisdiction over the BVI claim. And if we go on from there to 2249 in the electronic, 2212 paragraph 52, Ground 11 alleges the judge was wrong to hold, without any adequate explanation, the governing law with BVI law. Claimant claim has no alternative, no significant connection with BVI. Judge should have held the governing law with Russian law, being the law of the country with which claim has its closest and most real connection. Ground 1 alleges the learned judge ought to have taken into account the fact that the extent, if any, of the substantive law of Russia was relevant, but there was no evidence before the court of any complex or difficult issue of Russian law. Learned judge dealt with the governing law at 99 to 101. It's not a valid complaint. Her judgment.
99.
Paragraph 54.
Paragraph. Oh, I see. I'm sorry. Yes, I've got it. Thank you. Yeah.
It is not a valid complaint. Their judgment does not reflect that she applied the double actionability rule to the underlying facts in arriving at her conclusion that the governing law for the tortious acts was BVI. The judge mentioned she was familiar with the rule. Common law and private international law enables the BVI court to determine whether BVI should be displaced by the foreign law of the place where the tort was committed. So, as opposed to BVI law applying, except to the far extent is not congruent, you apply the foreign law. The rule for the purpose of this case basically states to found a suit in tort in the BVI for wrong alleged to have been committed in a foreign country. 1, the alleged wrong must be civilly actionable as a tort is committed in the BVI. 2, the alleged wrong has to be civilly actionable in the lex loci delicti, i.e. the law of the place where the wrong was committed. Not necessary to be characterized as a tort, as long as the right of recovery. The recognition that double actionability rule should be applied with flexibility has given rise to an exception to Lim 2, which states a particular issue between the parties may be governed by the law of the country, which with respect to that issue has the most significant relationship with the occurrence. And the Privy Council in Red C, which we'll look at in a moment, considered whether this could extend to cover a whole claim. Lord Slynn reasoning seems to have extended it by stating, although such instances might be rare, the exception was not limited. The scope of the common law rules created much uncertainty. And then at 59, I previously found, excluding the alleged conspiracy and enforcement proceedings, Judge ought to have held the most significant elements of the Tortious Act that occurred in Russia, where I management tendered the allegedly forged guarantee, and so on. I therefore endorse the argument of I management that where the torts were committed in Russia, if they're to be actionable in BVI, then prima facie should be actionable under Russian law. Regarding alleged conspiracy within I management, it seems the exception to Lim 2 would apply. Counsel pointed out Lord Goffin against Biliada. The governing law may be of little importance when seen in the context of the case as a whole. It may also be borne in mind the burden of proof rests on the party, asserting that foreign law differs from BVI. In the absence of such proof, there is a presumption that foreign and English law, in this case BVI law, are the same. So a rather different view from the Court of Appeal. No evidence Russian law relating to the bribe is different from BVI law or complex. No evidence at all. Even if I management is entitled to benefit from it, the evidence was unhelpful. The Linen Judge inaccurately stated the governing law is BVI, although she was entitled to conclude any governing law, Russian law, was no different from the BVI law. So, with respect, that doesn't give any justification for an argument that where you don't know the lex loci delicti, you can identify some separate third party law. Can I now go to H2, tab 34?
It's the authorities.
In the authorities bundle, yes. It begins at 2616 in the electronic, 2570. And I'm going to pick it up, if I may, at 2632, 2586. And letter A, their lordships, having considered all of these opinions, recognise the conflict which exists between the desirability of a rule which is certain and clear, based on which people can act and lawyers advise, on the other, desirability of the courts having the power to avoid injustice by introducing an element of flexibility into the rule. They don't consider the rejection of the doctrine of the proper law of the tort as part of English law is inconsistent with a measure of flexibility. Boyce and Chaplin recognised it. They accept the law of England, recognise a particular issue between the parties litigation may be governed by the law of the country with which respect to that issue has the most significant relationship with the occurrence with the parties. Exception will not be successfully invoked in every case, even probably in many cases. General rule must apply as clear and satisfying ground as shown. Books show many exceptions.
I wonder if we're disappearing down a rabbit hole here. We could spend all day talking about Chaplin and Boyce and trying to work out the ratio. But this isn't really about governing law in the sense in which you use that expression, I think, in the context of forum non-conveniens. Is this not really talking about the double actionability rule required for proceedings to be brought in England or in wherever it was in the Red Sea case in Hong Kong? and then the extent to which certain issues, assuming that litigation can be brought in Hong Kong, the extent to which certain issues in the litigation might be governed by the lex fori rather than the lex loci delicti. So, for example, in Chapel and Boys, the question was whether general damages were recoverable, notwithstanding that the governing law of the tort was Maltese law, under which general damages were not a head of damage. It's not. I'm not sure really how on point this is. I mean, your point seems to be a very short one. That the governing law, in principle, is a relevant factor for forum non-convenience. Here, both courts agreed they weren't in a position to form any view as to what the governing law was, and the judges and the Court of Appeals leap to decide that governing law was Russian law because the employment relationship was governed by Russian law is illogical.
It's logical. And the only point I was trying to make out of this, I've got 2 points to make, and I move on to my next point, is that and this is a case where at the end of 25A6, the Lordship considered, or the committee considered, that in principle exception can be applied in an appropriate case to enable a plaintiff to rely exclusively on the lex loci delicti. There's no suggestion that you can rely on the law of some third state and treat it as the governing law. The error may have crept in because in Boyce and Chaplin, one of the matters to which Lord Wilberforce referred and which Lord Hodgson approved was the Second American Restatement, which was very different but talked about in certain cases. One may apply the rule of some other state, meaning another state within the United States. Yeah. It does not mean some other country for general purposes. I'm going to go back, if I may, to the first, in a sense, crucial error of the Court of Appeal in concluding that Russia was an available forum, because having dealt with the question of applicable law and governing law, we say that the learned judge simply got it wrong. If we could go back to Bundle A, and first of all to Justice Walbank's judgment, he deals with available forum at page 114 in the electronic bundle, 109 in the paper bundle in tab 7. Letter 4 on page 114. Both sides have experts issued a joint report. They agree the Russian courts have jurisdiction against the Russian defendants. These aspects represent only a small part of the overall proposed claim, submission I've already made. The experts disagree about whether the Russian courts have exclusively jurisdiction over such claims. They also disagree over whether the claimants will be able to consolidate all their claims against all the defendants and bring such claims in one Russian court. The claimant's expert says there is no single court in Russia with jurisdiction over all the defendants. At best, the claim will have to be split between different Russian courts to determine the claims against the Russian defendants and those against the foreign defendants. So even if you got to Russia, then you're in two courts. The defendant's experts says it will be possible for the claimants to consolidate all their claims and have the Russian Court of General Jurisdiction determine them. The claimant's expert says the Russian Arbitrage Commercial Court would not have jurisdiction over non-Russian defendants. The defendant's expert says the Russian arbitrage could. This leaves the question of the Russian court's jurisdiction and competence and availability in a state of uncertainty. Mr. Mobley Smith urged I have to decide which opinion I prefer. He refused to do so. He said they were both very, very able advocates arguing opposite contentions which hadn't been tested. I cannot and will not attempt the impossible. In my submission, that's entirely correct in those circumstances. In respect of the jurisdiction challenge, This means those defendants who have put their applications on that basis do not discharge their burden of proof of satisfying me there is some available forum with competent jurisdiction to try the claim. So he concludes on the basis of the stay defendants that they haven't established it's an available forum because, not having preferred one expert to the other, it is clear that there is cogent evidence before him that you can't bring all claims in one court and you can't bring claims against the foreign defendants at all because the arbitrage court won't accept it. Therefore, it cannot possibly be said that there is an available forum which is by far and away the most suitable so as to justify a stay on the traditional test. But he then goes on.
I'm sorry, just before you do that, the Russian arbitrage court would not have jurisdiction over the non-Russian defendants. What about the other court?
Well, what Mr. Kulkov says is that the Russian defendants, Rogalsky and Permitkin, would be in the Court of General Jurisdiction. Because if the claims are joint, that is, that every defendant is jointly and severally liable, which is quite difficult when there are separate bribery schemes, then they can all be brought in the Court of General Jurisdiction. But if they can't, then the commercial claims against foreign defendants go into the arbitrage court. Professor Asoskov says, no, these are not joint claims. The court will not put them all in the Court of General Jurisdiction. They would have to go into the arbitrage court, but the arbitrage court will only accept jurisdiction over foreign defendants if either a preponderance of the breaches or a preponderance of the loss was suffered in Russia. So on that basis, and where the evidence was that nobody knew where the wrongs were done, and we were saying they were done outside Russia, it was not possible for the state defendants, BVI companies, to establish their burden of proof. The learned judge then, in my submission, quite correctly says, well, now I must look at the service-out defendants. And for the service-out defendants, the boot is to some extent on the other foot, because they have to show that there is no more suitable forum, and that BVI is therefore the best forum for the ends of justice. And therefore, he says, that we must show that BVI is clearly or distinctly the appropriate forum for the trial of the dispute. This goes beyond the availability of another forum. For the purpose of this part of the inquiry, I'm prepared to assume that Russia might be an available forum of competent jurisdiction. So he's not going back on his previous finding. He's saying, because there are conflicting evidence, and Mr. Kulkov might be right, then I'm assuming for these purposes that this may be a forum of competent jurisdiction. Because he had that evidence from Mr. Kulkov, he was in a different position to Justice Ferrara. And he then went through a number of arguments as to why, in those circumstances, he considered that a BVI was a more appropriate forum for these necessary and proper parties to join litigation which would, as a result of his first finding, be carried out in BVI against the BVI defendants in any event. And I'll look at those briefly. They're in my written submissions, and I'll touch on them for 3 or 4 minutes when I finish my current point. So that, in my submission, was a perfectly proper approach by the learned judge to the expert evidence before him. Can we now see what it was that Justice Webster in the Court of Appeal did? And we can pick it up at 44 printed, 48 electronic, paragraph 25, where he deals with the section BVI Defendant's Jurisdiction Application. And he quotes from Justice of Appeal Gordon in IPOC, referring to and summarising Lord Gough in Spiliada. And Justice Webster summarises it on page 50 or 46. Briefly stated, when the defendant seeks a stay of an action on the ground of forum non-convenience, the court should determine whether there is another available forum, stage 1, whether that forum is more appropriate for the trial of the case, stage 2. If there is another forum that is more appropriate, a stay should be granted unless there is a risk the claimant will not receive justice in a more appropriate forum. Burden of proof on the defendant's first 2, claimant third stage. All correct there. Then he goes on to look at Russia as an available forum. He refers to the disagreement between experts, sets out Mr. Kulkov's view at paragraph 30, all in the General Jurisdiction Court. Mr. Kulkov's alternative position, so we said Professor Askoff disagrees, I've already said that. Mr. Kulkov's alternative position, if the claims could be split, the claim against the Russian defendants will remain in the Court of General Jurisdiction. Claims against the non-Russian defendants will be tried by the arbitrage court. The arbitrage court would have jurisdiction over the non-Russian defendants if at least some part of the losses were suffered by the claimants in Russia, or at least some of the tortious actions were committed in Russia. So what Mr. Kulkov comes down to is that they may have to be split, but if they are, the arbitrage court will still take jurisdiction, and indeed the Court of General Jurisdiction will take jurisdiction, if at least part of the losses were suffered in Russia, or some of the tortious actions committed in Russia. Professor Askoff disagrees. Arbitrage court does not have jurisdiction over the foreign defendants, because the court will only have jurisdiction if the tortious actions by the defendants, the losses incurred by the claimants, took place in Russia. As none of these matters occurred in Russia, the arbitrage court would not have jurisdiction. This was criticised, but I'm satisfied it's an evidence-based conclusion, and the professor did not rule out the possibility of the arbitrage court having jurisdiction over foreign defendants in a factually appropriate case. That's right, because what the professor says is if the tortious acts and the losses incurred in Russia, the arbitrage court would take jurisdiction. So those are the facts that have to be, but you have to have those facts before they will take jurisdiction. Further disagreements not relevant. Mr. Mobley Smith says that he had to decide. He contended that the judge was an incorrect approach and refers to Mr. Justice Arnold in first instance in VTB Capital, where he can take account of things such as the cogency of experts. And of course I accept you have 2 expert reports, and one's very thin and very ill-reasoned without 2 references, and the other is by an eminent professor with 153 references and well-reasoned. You may place more weight on the latter than on the former. But that's not what Justice Warbank did. But what Justice Appeal Webster says, it follows from the reading of the transcript, Warbank adopted a similar approach, because having found, as he did in the preceding passage, that is to say that he was not satisfied that there was a available forum for the purpose of the stay, he went on to say, for the purpose of this part of the inquiry, I'm prepared to assume Russia might be an available forum. The part of the inquiry he was referring to was a claimant's application to serve out. It's difficult to see how Russia could be an available forum, competent jurisdiction to serve out, and not one for the purpose of resolving the jurisdiction application. In any case, what is important is he didn't make specific findings on the disputed expert, but considered the cogency of the evidence in carrying out the balancing exercise required of him on a forum application. So what the learned justice has done is to treat Justice Warbank saying, I've now got to look at it on the basis the burden of proof is on the claimant, as a finding, not that finding that Russia was an available forum, but an assumption that it might be for the purpose of that test, because it hadn't been proved that it wasn't, because there was a dispute. And he then goes on to say, at 38, his approach to the expert evidence was correct. He found he couldn't resolve conflicts, but he went on to consider the agency. And one finding was that Russia might be a competent forum for the purpose of the service out application. I could just quote for the little bit in 37. The experts subsequently engaged by both sides show that this proposition is debatable at best. There are circumstances which the Russian court could, in some combination, proceedings perhaps in courts, determine matters even involving the following defendants. That's a possibility. So it's all referring to if the loss and if the torts occurred in Russia. And then Justice Webster, in his capacity as a reviewing tribunal of a discretionary exercise, says, I would go one step further and draw from the conflicting evidence that depending on the evidence before the court in Russia, there could be either a single trial of the defendants before the Russian Court of General Jurisdiction, or if they were split, separate trials being tried before the arbitrage court. The latter part is very similar to the judge's observation. In the circumstances, I find, in respect to the expert and factual evidence, in all the circumstances of the case, that Russia is an available forum. Well, with great respect to the very experienced Justice of Appeal, that simply doesn't follow. This is all might be if the torts were in Russia, if the loss was in Russia, it might be possible either in one court or in two courts. Now, to oust the jurisdiction of BVI in favour of two courts in Russia is of itself highly undesirable. But there's no certainty that it will succeed. And where there is no evidence to suggest that a single act or omission was carried out in Russia, and let alone the preponderance as required by Professor Asoskov, and where the losses were suffered mainly in Switzerland by ECTG and elsewhere, you simply can't find that Russia is an available forum for the purpose of the set-aside, because it's not clear that they will get justice. And if I can take a practical example, and this leads me into my additional points, and I'm going, if I may, to take 5 minutes of my half hour, but no more than that. In this case, where the defendants have kept their powder dry as they are entitled to, haven't really said anything, no defence, no argument, no statement about where anything happened. You go to assume that there was no successful appeal. Assume we went to Russia. It is perfectly open to these defendants to say, there's no evidence at all of any torts in Russia. There's no evidence at all of any loss in Russia. The sales were all made by the Swiss company. You have no jurisdiction. It is absolutely not demonstrated nor conceded that they would accept the jurisdiction of the Russian Court of Arbitrage, let alone that the court would accept something which fell outside their remit. So it's wholly unsatisfactory and unsuitable. And in my submission, utterly wrong for the Court of Appeal to say it's an available forum because in some circumstances it might be possible. That could be a factor in the set-aside, but it cannot be a factor where he found it, which is in the stay side with the defendants served as of right. And that part of his judgment must, in my submission, fail. I want to come on briefly to some related matters, because when we get to the end of the Court of Appeal's judgment, there are a number of matters that the Court of Appeal disagreed with and in effect used in their support of Russia as a more appropriate forum, which Justice Warbank had used in support of his conclusion for the set-aside defendants' service out, that it was not. Witnesses, Court of Appeal agreed with the judge, not, in this case, a relevant factor, nor language. Page 64, electronic, 60 in the transcript, in the record, volume A, incorporation in the BVI.
I don't know, are you going to come on, I mean, in relation to the hypothetical Russian proceedings, there are obviously important points about the sort of remedies available and also
Yes.
about limitation. Are you going to come on to those?
Yes, what I'm going to do is I'm going to... the learned judge found that there were differences in remedies and they were better. The Court of Appeal didn't really address those.
Well, they basically say it's tough luck.
It's tough
as far
luck.
as remedies are concerned, that's the disadvantage they'll have to deal with. And in relation to limitation, there was an undertaking given on behalf of certain defendants, and to say in relation to the others, the claimants would have to apply for an extension of time in Russia.
Which might or might not succeed, bearing in mind that the principal person who hasn't given the undertaking is Mr. Rogalski, who is, if you like, the anchor to Russia in the first place, Mr. Pomitkin playing no real part in these proceedings at all.
I mean, I might have thought in a case of this nature, being restricted to personal remedies and not having equitable and proprietary remedies might be a matter of concern.
It's a matter of real concern, and one of the points I was just going to make by reference is the Aberdeen Data, which you'll be familiar with. The head note picks up the typo in Lord Diplock's speech referring to some personal or judicial advantage. It's clear from all the other speeches and from everything else it's a juridical advantage, which is in mind. But people seem to quote from that. We say that these are absolutely legitimate juridical advantages which the judge found in terms of remedy and which should sway the tribunal. But we say that's all part of the judge's discretion, properly found, and the Court of Appeal don't really deal with it. I want to pick up the question of incorporation in the BVI and specifically make some oral submissions about that and on the effect of the defendants remaining silent. Now, I entirely accept that the mere fact that a company is incorporating the BVI is a weak connecting factor in the exercise of the discretion. One imagines BVI companies who are landlord and tenant of an apartment in London having a dispute. No connection to the BVI apart from the fact they both incorporated that. There are many other commercial deals where BVI companies are used which have no real connection to the BVI. But this is a case in which if we are right, this fraudulent bribery scheme was promoted, protected, and assisted by the use of an offshore jurisdiction, by using multiple BVI companies into which one cannot look because you can't get their accounts and you can't find their directors. They've chosen to use the BVI as a conduit for money laundering the proceeds of that, with BVI directors actually carrying out acts for which they're accountable in the BVI. 4 of them, or 2 of them are now in liquidation in the BVI, having their actions investigated. And in this age where the role of offshore entity or offshore jurisdictions in protecting people's commercial activities that they would like to hide is under greater and greater scrutiny, for the BVI to say, we couldn't care less if people use our companies, not just as owners, but actually as the means of concealing an international bribery scheme for their employees. And it is relevant in my submission. And we quote, and I don't know if it's been available.
But isn't that a matter for the BVI Monetary Authority? How it regulates and whether or not there's sufficient transparency in the corporate area?
Well, they can make it more transparent. But if entities from around the world, including some from jurisdictions where it's difficult to sue people and to fine people, deliberately use BVI, for BVI to say, we simply wash our hands of it. The learned judge, sitting in the BVI, now appointed for 3 years as the BVI resident commercial judge, thought it was relevant for that jurisdiction and its protection. 8, 9, probably 950,000 companies by now, I can't remember, it keeps going up. If all of those can be used, and anything that happens about them, and this actually happens, so to speak, in Road Town, is ignored, it seems to me that it is a factor which the court is entitled to take into account. We referred in
Your clients are involuntary creditors. I just said your parties are involuntary creditors. They were not contracting parties. If their claims are good, that is.
The other point I just want to pick up is the criticism of the judge for saying these defendants haven't said a word about anything. VTB and Nutritech, Lord Clark, if defendants choose to stay silent as they're entitled to do so, they can't complain if they don't get the benefit of the inferences they would like to have drawn. They've said nothing about their role. They've said nothing about connection with Russia. They've said nothing about what jurisdiction any acts were committed in. They can hardly complain if the BVI court, quite correctly, identifies BVI as being the best place to deal with it, cannot identify another lex loci delicti, and regards the BVI as the most appropriate place for it. And he was entitled to make that submission. And that, in a sense, is why we're in this muddle with no lex loci delicti. They make the point about we don't know about the de facto directors of the companies or the de jure directors. They've chosen not to tell us. And the judge was entitled to say, if they want us to exercise our discretion in favour of the defendants on the forum, then they can't complain if they don't actually provide us with material which is relevant. The last thing I wanted to say was when dealing with the question of BVI and forum, in Bundle J, telesystems, particularly paragraph, it's in paragraph 69 of our written submissions, and it's pages 20. I've taken 11 and a half minutes, I think, or 12. I'm very grateful.
Mrs. Fulton, do you follow? Mr. Rees.
By way of brief introduction, I would say that there is no point of legal principle in this appeal, and the Court of Appeal got it right for the reasons that they stated. The appellants complain that the Court of Appeal were too willing to interfere with the evaluative decisions of Mr. Justice Wallbank at first instance. But on behalf of the 10th to the 13th respondent, we say that complaint is misplaced because Mr. Justice Wallbank unfortunately fell into an error of principles, and he exercised his discretion erroneously, such that the Court of Appeal really had no choice but to re-exercise their discretion on the evaluative process. And if I can just identify some of those key areas of what we say are errors of principle from Mr. Justice Wallbank at first instance. If we look at the extemporary judgment of Mr. Justice Wallbank at Bundle A, electronic copy, page 117, hard copy, page 112. He goes through, this is where his judgment essentially starts. Line 10. I cannot overlook several aspects, or at least a number of aspects, which are peculiar to this matter. First of all, the claimants who have no connection with the BVI have, upon mature reflection, decided to step in to this, for them undoubtedly foreign, BVI legal arena in an attempt to vindicate their rights. It's a well-known fact that the BVI is an expensive place in terms of legal costs, on par with London and New York, to name but two. That choice that the claimants have made demands the respect and understanding of this court and is a factor I must take into account. Well, pausing there, it is to be regretted that that is, of course, an example of a first instance judge falling into error of principle in taking into account what is the claimant's or plaintiff's own decision as to where to bring the proceedings. It doesn't form part of the Spiliada test, and Mr. Justice Wallbank was wholly incorrect to take that into account at first instance. And the Court of Appeal, at paragraph 69 of their judgment, which is electronic bundle 65, hard copy 61, correctly disagreed with the learned judge at first instance, and correctly said, I think the judge erred in finding that the claimant's choice of suing in the BVI is a factor that must be taken into account. The unilateral and self-serving decision of a claimant to start proceedings in the Virgin Islands is not a factor that should be taken into account when considering the balancing exercise to determine the natural forum of the trial of this claim, far less as a factor favouring the BVI as the appropriate forum. And the claimants have obviously not sought to appeal that part of the Court of Appeal judgment. And so, as such, the appeal today should proceed on the basis that Mr. Justice Wallbank did exercise his discretion erroneously at first instance by taking into account an irrelevant factor.
What are we to do? What should we do were we to come to the conclusion that both courts had fallen into error?
Well, then you will probably have to re-exercise the evaluative judgment in Spiliada, which with lots of case authorities, as you know, which suggests that that's a regrettable thing for an appellate court to have to do. But in the end, of course, the discretion is available to you. to re-exercise the discretion. Although there are many authorities which suggest caution should be exercised before that is done, which I can take you to if you wish. But by way of brief summary and introduction, at paragraph 128 of the 10th to 13th respondents' submissions, we set out the reasons where the first instance judge, this is in R1, page 32 of the hard copy, where the judge fell into error at first instance, which meant that the Court of Appeal had no choice, in effect, but to re-exercise the discretion under Spiliada. It's in the e-bundle at page 1680, the hard copy, R1, page 32. We say that he should have made, Mr. Justice Walbank should have made a specific finding on the governing law of the claim. I'll come back to that and make substantive submissions on that in a moment. We also say that he should not have relied on Dicey's Rule 25.2 to find that BVI law applied to the claims for the reasons set out in the written case. And again, I'll develop my oral submissions on that in a moment. And he attached far too much weight to the place of the incorporation of the companies. Mr. Justice Walbank, in his decision, said that that was a significant factor. And he says that in his judgment, Bundle A, page 118 electronically, 113 hard copy, lines 5 to 11. I cannot accept that submission. Implicitly, those alleged bribe takers in particular want me to ignore that they had a purpose in using BVI companies. The 8th and 9th defendants formed and used at least 5 BVI companies. There must have been a reason for this choice. It cannot have been sheer coincidence. And then line 20 to 22 of the same page, he says, this is important because mere incorporation of a company in the BVI is insufficient for this court to become the appropriate forum for trial of a claim. And then over the page 119 electronically, 114 hard copy, lines 12 to 14, he said they should expect that if they use the BVI vehicles to perpetrate their frauds, the BVI courts will hold their companies and them to account. So, Mr. Justice Walbank placed very considerable reliance upon the place of incorporation of these companies in the BVI. And in our respectful submission, the Court of Appeal were correct in saying that it is only a neutral, or it is only a factor to consider in relation to the weight to be attached to the available forum.
But isn't that all the judge has said? He says mere incorporation is not enough. And he's,
well, I think he goes...
114 is surely just identifying another factor.
Well, I think he's going further, if I may suggest. At page 119 electronically, 114 hard copy, in particular, they should expect that if they use BVI vehicles to perpetrate their frauds, the BVI courts will hold their companies and them to account.
Yeah, but that's in the context of the paragraph as a whole, where he says they've taken care to be seen to carry out their scheme anywhere else than Russia. And the BVI is simply an example of that.
Yes.
And he's not, you can't take that last sentence out of context, can you?
Okay, I accept that. But a great deal of emphasis in this appeal is placed on the location or place of incorporation of companies, and we respectfully submit that is an overstatement in relation to the current law. The learned Justice Webster, paragraph 71 of his judgment, page 66 electronically, 62 hard copy, identifies where the first instance judge fell into error and identifies those three areas. And therefore, at paragraph 72 of the judgment, he says, second sentence, I find the judge committed errors of principle leading to an incorrect assessment of the connecting factors and the conclusion that Russia is not the more appropriate forum for the trial of the action. And then goes on to say, paragraph 73, that this is a Russian fraud, effectively, in which the BVI companies were used as instruments. It has nothing to do with this jurisdiction. Now, in terms of the location of the incorporation of companies, it is a factor, but only one factor. And one has to look at all the circumstances of this case. And we've set out in paragraph 11 of the 10th to the 13th respondents' case what are the connecting factors, we say factually, which connect this case to Russia. Obviously, I'm not going to go through each of those points, as I know you'll have read paragraph 11 of the 10th to the 13th respondents' case, which is page 5 and 6 of bundle R1. And also, in paragraph 8 of the 18th respondents' case, you'll see at page 43 and 44 of bundle R1 the connecting factors there to Russia. So if I may make my position clear in terms of the reliance on written cases. Obviously, I rely upon the written case that I've submitted, and also rely upon the written case of the 18th respondent. There is only one difference, really, between those two written cases, which is the approach to Rule 25.2 in Dicey. I, on reflection, having the benefit of reading Mr. Crow's case, adopt his analysis on Rule 25.2 and do not adopt the analysis put forward in my written case in relation to Rule 25.2 in...
Sorry, can you show us where Mr. Crow's submission is?
Yes. It is at page 47 and 48.
Is it in paragraph number of his case?
It's in paragraph 16 through to 18 of his written submission. Again, I'll develop this orally in a moment, if I may.
And which paragraphs are you abandoning of yours?
The analysis under the case of Iranian oil, offshore case. So really from '57 through to 73.
73?
Yeah. On analysis, I think Mr. Crow has the better argument there in relation to Rule 25.2. But if I may just briefly set out some of the key factual circumstances in this case, which should lead this court to be comfortable that Russia is the appropriate forum and Russia is the governing law in this case. You'll see at paragraph 11 of my written case, pages 5 through to 7 of bundle R1. Set out a large number of factors which connect this case, we say, well, not to the BVI, certainly, but much more likely to Russia. And one of the key facts in this case, which it's important to emphasize, is where the bribes were paid. They were paid not in the BVI at all. There's no evidence whatsoever of that. They were paid in Cyprus and Singapore and Latvia.
Do we know that?
My Lord, yes. In the statement of Popov, let's take his first statement, if I may, which is in bundle E behind divider 48. And starts with a hard copy on page 1141. Which is in the E bundle, page 1172. He talks there about a meeting with...
Remind me who he is.
He is the person who gives the evidence on behalf of the claimant. He's the Deputy Director of the General Matters Department of the first claimant. And at paragraph 35 of his first affidavit, he sets out that there was a meeting in March of 2014 in Norway, which he attended with counsel for Eurochem and Yara and its counsel. Now, Yara is this Norwegian company that was involved in this bribe scheme, who've admitted their involvement in the scheme and have indeed been fined a considerable amount by the Norwegian authorities for their involvement in this bribe. And you'll see at paragraph 38 of the same affidavit that the reference is made to the De Brouw report, which is said to compel...
I'm sorry, I must be looking at the wrong one. I thought we were in tab 61, his sixth affidavit. Is it another affidavit?
Sorry, I took you to the first affidavit.
His
Yes,
first
please.
affidavit?
Yes, please. Bundle E, tab 48,
Oh, tab 48, right, I'm with you now.
and hard copy 1142.
Thank you.
And there he summarises the De Brouw report, which is said to be attached, but is not in fact attached within the bundle. And it sets out what this inquiry of this law firm in Amsterdam has undertaken in relation to the bribe scheme. And you'll see that where that summarises where the money was sent. And then at paragraph 39 of the De Brouw report, again, it contains documentary evidence, including wire transfer, bank statements, etc., and that these were paid into a bank in Singapore and Cyprus. And paragraph 40 refers to that also being the involvement of the Bank of Cyprus. And so you see over the page 1144, the investigations that Eurochem have undertaken.
Sorry, does that mean that all bribes were paid into those accounts?
It's not clear because the Brouw report is not attached.
No.
But I think it's an accepted fact that all bribes were paid to either Cyprus, Singapore, or Latvia. I think that's an accepted fact.
Looking at this, it looks as if it was the Yara picture that is being investigated.
It could be.
It does look like a smaller amount than you don't otherwise expect.
Yes, it could be. But
So where's the acceptance that all bribes were paid?
I think if we look in the statement of agreed facts, which is in bundle G6, hard copy, page 1558.
Paragraph 10?
F, to 10F.
Yeah.
Yes, in the e-bundle, 1608.
Well, that's not necessarily exhaustive.
I'm sorry, Lord?
On its face, that's not necessarily an exhaustive, an agreement as to what happened to every bribe that was which is the subject matter of litigation.
How could it be without full disclosure?
And if one looks, please, at Popov 6, page 1248, in the hard copy. (1286) in the e-bundle. You see the BVI registered defendants then laundered the proceeds of the dishonest bribery scheme, including those intercompany transfers after receipt, and used them to acquire substantial real estate holdings, securities, bank accounts and other assets around the world in Turkey, Italy, Bulgaria, Portugal, Netherlands, Finland, UK, Panama, Latvia and Russia. The point of this really is to make the point that whilst this was a bribery scheme with an international scope, it didn't really involve the BVI whatsoever, save for the incorporation of those 5 companies.
Sorry, I mean, I thought we were trying to say why it involved Russia.
Yes, and why? Well, the connecting factors to Russia are set out in paragraph 11 of my written case. And also, when you look at where the bribes were paid, it certainly does not support that BVI is a connecting factor in relation to the local.
I see. You're saying none of the bribes were paid, as far as we know, were paid into BVI.
That's right.
Accounts.
That's essentially the point I'm making in terms of a key fact in this case, which means...
I appreciate it's a different point, but while we have this in front of us, it might be said that paragraphs 45 and particularly 46 illustrate the importance that tracing remedies and proprietary remedies might have in this case.
But that's the location of the assets around the world.
Yeah. I mean, we've been told that under Russian law, any remedy would be restricted to a personal remedy. Whereas, which may or may not be may or may not be valuable. Whereas apparently it's possible to trace the bribes into property around the world.
Yes. But in terms of the alleged importance of incorporation in the BVI, we say that much too much is made of that. And the Court of Appeal got the correct approach in relation to that at paragraphs 67 and 68 of their judgment. Perhaps we could just look briefly at that. Because in 68, you'll see in the second paragraph, the object of a forum application, this is, by the way, e-copy 65, hard copy 61. The object of forum application is to determine the forum to which the claim has its closest connections. The domicile of a company in a particular jurisdiction is technically a connecting factor, but only in a limited sense, and very little, if any, weight should be attached to it in the balancing exercise. What is important is where the company's agents carried out the activities that led to the claim. There is no evidence the BVI defendants conducted any of the relevant activities in the BVI. The judge should not have attached any weight to the use of these companies or expect this factor to be treated as favouring the BVI as the appropriate forum. And we say the Court of Appeal got that right, and that's based on high authority. And if we look in the bundle for the case of nylon, which is H2, page 29, H2, tab 29. We'll see this was a Privy Council case, 2015.
Electronic number, please.
Yes. 2476. Thank you. You'll see that this is a decision involving a case where Lord Collins gave the principal judgment. And he goes through the relevant case in that particular appeal and the facts relevant to what that was about in terms of the company and how that could have fallen within a relevant factor in terms of the Spiliardi test. Paragraph 60 of the judgment, which is page 2450,
(2492).
He deals with paragraph 60. He says, this is not a case involving any of the domestic issues referred to. The relevant principles have been developed in the context of such issues as those arising between members or issues relating to the powers or organs of a company, the appointment of directors, the extent of members' liabilities for debts of the company, and the right of shareholders to bring derivative actions. It then says the Court of Appeal relied on Bannister J's statement that if foreigners incorporate companies in the BVI, they must expect to have to come to the BVI to litigate disputes going to the membership and administration of such companies, but the Court of Appeal ignored the context of those remarks, which was consideration of the forum convenience if, contrary to his view, there was a viable cause of action against Nylon for breach of contract. The issues in this case are not about the organisation or administration or the internal management of a company, they are about the terms of an alleged contract to which is not suggested Nylon was a party. So the point being made there is that for it to fall within the gateway provision under Rule 7.37 7, which is in the hard copy bundle, page 1670, E bundle 1694, to get service out of the jurisdiction for a claim about a company, you'll see that a claim that form may be served out of the jurisdiction if the subject matter of the claim relates to A, the constitution, administration, management or conduct of the affairs, or B, the ownership or control of a company incorporated within the jurisdiction. So there's a very specific, narrow gateway in relation to service out proceedings in the BVI in cases for claims about companies. And this is not a case, we say, where the constitution, administration, management, or conduct of the affairs is involved in relation to this case. And so Mr. Justice Ferrara was correct at first instance not to give permission to serve out under 7.37A. The Cayman case authorities have been referred to at the end of my learned friend's submissions to you. And he refers to the case of Telesystem. And that has a very particular public policy which is unique to the Cayman Islands and is not followed, I believe, anywhere else in the offshore world. So the case of Telesystems was delivered, I think, in full to you yesterday, Bundle J. Previously, there's only just a summary of the case provided. And in the hard copy, you'll see that...
just a moment, please, just to
Thin one.
find it.
Thin one which came
Oh, yes. Yes, got that now, thank you.
Sorry, I haven't got it just yet.
Thin one, Mary, which came in this morning, I think. One of the problems is it's very difficult to see the letters on these. The
Yes.
letters seem to be written in rather sort of faintly. But this was one which actually, I found
That's-
on my desk this morning, so I
Yes.
haven't had time.
I received it late yesterday afternoon in Chambers.
Is there a spare copy I could use?
Yes, we have mine.
If I may.
I've got the
Oh,
electronic.
spare copy.
Here you are, Mary.
Thank you.
And it's page 23 of this case authority where the Court of Appeal in the Cayman Islands, sitting there in the year 2002, sets out the public policy considerations relevant to that particular jurisdiction. And you'll see from page 23 that the argument that was being raised at line 4 under public policy considerations is that public policy was said to arise because of the status of the Cayman Islands as an international financial centre and the recent initiatives by international financial community, principally the Financial Action Task Force. We don't have anything like that in this particular jurisdiction of the BVI. And there they say it's alleged by the appellants that over 90% of Cayman registered companies are either exempted limited companies, ELCs, or non-resident companies, NRCs, that an ELC must carry on its business mainly outside the islands and is prohibited from doing business within the islands, save in furtherance of its business outside the islands. The same rule applies to limited partnerships, and that an NRC cannot carry on business within the islands. The learned judges go on to say, the appellants complain that as the trial judge based his reasoning partly on the fact that 3 of the respondents carried out their business outside of the Cayman Islands, a forum non-convenience challenge by an ELC or NRC would always meet with success. If said, the appellants, a forum non-convenience application will succeed solely on the basis that the business of a Cayman Islands company is carried on outside the Cayman Islands. This means the legal requirements to submit to the jurisdiction by ELCs and NRCs is illusory. The consequence they submitted would be that over 90% of Cayman companies would not be subject to the jurisdiction of the Cayman courts in any meaningful way. Then, so this is just to explain why the Cayman Islands is different to the BVI. And why they have a public policy there, because that's what the Court of Appeal decided in Telesystems.
You say it's different because because recent initiatives by the international financial community to improve financial conduct in offshore jurisdictions and the like.
Yes.
You say those don't apply to the BVI?
Well, if I may just to finish off the point which the Court of Appeal were making on public policy, and then I can answer your question. At the end of bottom of page 24, they say, although both cases referred by the learned judge are decisions of the House of Lords, they do not have the force of statutory instruments. It cannot mean that because of the fact that public policy was not specifically mentioned in the House of Lords decisions under reference, if a case should arise outside the United Kingdom where public policy is put forward as a relevant consideration, the Court cannot consider public policy as a factor determining the issue of forum non-convenience. Now, pausing there, obviously the case of Luby and Cape had been decided 2 years earlier in the House of Lords. And this was not a case which was referred to the Court of Appeal in Cayman 2 years on. And so when the Cayman Islands, and I'll take you to Luby and then we'll perhaps break for lunch. When the Cayman Islands came to their decision at page 25 of the judgment in Telesystems, they say at the top, for public policy reasons, A, the state of the Cayman Islands is an advanced and reputable financial centre, B, is a jurisdiction which can and does deal with international disputes between parties who use Cayman Island companies in their structure, are factors that can be taken into consideration in an appropriate case when deciding foreign non-convenience issues that relate to ELCs and NRCs. But when they looked at the question of public policy in relation to the corporation of companies, bottom of page 225, they said, we understand the appellants to be saying the public policy factor is so strong that once an ELC or an NRC defendant is served as of right in the Cayman Islands, a foreign non-convenience application should be rejected. We do not agree. We hold that public policy is an important factor to be taken into consideration by the trial judge, but it does not trump all other factors. And so it is only a factor. But in the case of Luby...
Well, perhaps we can look at the case of Luby after the short adjournment.
Well, yes.
Thank you.